This is Judge Krier again. Whoever is appearing without clothes on needs to dress themselves or get off and get out of my courtroom. It's designated as Michelle Mickle, I think. So whoever that is needs to fix it. Or I will hold you in contempt. All right, this is Judge Krier again. It's 8:30. We're going to begin the 8:30 docket. The first case on my docket is 09CA9571, Bank of New York Mellon versus Gary Holtzhausen. This is a motion to cancel and reschedule a foreclosure sale. Who's here for the plaintiff?
Good morning, Judge. Attorney Jason Silver for the plaintiff.
All right, anybody here for defendants? All right. This is, I think, your motion based on the foreclosure moratorium. I think you stated in your motion that the residence is occupied by the owner. Is that correct?
Yes, ma'am. And I anticipated you would have read the motion, and that's accurate. And our client's applying a hold. My client did ask that I convey an additional request that we cancel the sale and not assign a specific new date that we could file a new motion.
Well, what I'm going to do is put you on a status conference date rather than a sale date, probably in August. I'm not quite sure when I'm going to hold this docket. I anticipate that my bet is that the courthouse is going to be fully operational in the fall, and that the foreclosure moratorium will be lifted sometime this year. I don't know when, but sometime. So I'm hoping by August, maybe we'll know better what's going on. So you'll get an order from us setting this for a status conference.
All right, so the sale will be canceled and a status conference will be ordered. All right.
I'll need an order from you with regard to canceling the sale, and you can just reference in there that the court's going to set it for a status conference on a date to be determined.
Thank you, and stay safe. And yes, I hope things continue to get better.
Me too. All right. Next case, hold on, is Mike and Julie Macchia versus First Protective, 20 CA 1081. Who's here for the plaintiff?
This is Attorney Alex Perkins Law Offices on behalf of the plaintiffs, the Macchias.
All right, and who's here for First Protective?
Good morning, Your Honor. Esperanza Briscoe on behalf of First Protective.
All right. This is plaintiff's motion to compel deposition of defendant's corporate rep and field adjuster.
Yes, Your Honor.
We're arguing about this, really?
Yes, Your Honor. Unfortunately, I wasn't sure if we were going to get to this hearing today. I was hoping that we didn't have to, and I didn't want to ex parte anyone because I know counsel did mention last night that she claimed that she didn't get the notice, even though it was noticed. And we had this discussion over a month ago about backstopping this because she was going to get us dates. They agreed to provide us dates. They never did. Counsel did have a firm change, but she's still the counsel of record. She's been counsel of record since January. She then changed her firms and kept the file. The substitution of counsel just came in April 12th, but this was noticed back in March, and we actually sent the notice to both her old firm and her new firm because she and I had talked about this and the need for getting these scheduled because we've already had an arbitration, there was an award, and my clients are elderly. I'm just trying to get this case moving, and we are under the trial court deadlines we're already beyond some of the deadlines, and discovery for fact witness cuts off in May, and I have not been able to get the deposition dates. And I understand that, there's always some delay when you're changing firms, but, this has been several months, and, we all have busy lives, and we all have.
Okay, got it.
Families.
All right, so counsel, what's going on here?
Your Honor, we didn't just change firms. We opened a new firm. I don't even know if I have this case yet. I know that the case was assigned to us. I don't know that we have the file yet. I've asked Mr. Perkins.
Well, you filed a notice of appearance, so.
I did, Your Honor, but I don't know what this case is about. Yesterday, unfortunately, I was in the hospital with my elderly mother, and I asked him to give me a few dates, at least to get back to the office to see what this case is about. I don't think there's going to be an issue, but I don't know the case, and I don't even know.
This isn't a Hurricane Irma case, counsel. How complicated could be. And you know that you've been on the case. So the motion is granted. I want these depositions taken within the next 60 days. If you guys have disagreements, and let me just point out a couple things which you may or may not want to include in your order. Giving somebody one date as possible dates for deposition does not qualify as giving people dates. 2 dates, now you're getting there. 3 dates, yeah, definitely. And then counsel, you don't get to just say none of those dates work for us. That's when I frequently have people in front of me on these types of issues, then they come back around on other issues, such as, none of the dates worked. So you're going to both have to be cooperative in terms of finding these dates, but the motion's granted. This is not complicated. I'm surprised you're even here. And I will reserve, however, on an award of attorney's fees with regard to this because of what you've told me with regard to firm changes, establishment, hospital, things like that. And if I'm reserving on entitlement as well as reasonableness, because this is not an evidentiary hearing, and you have made some representations that there might be some extenuating circumstances. But I will tell you what I often do in these types of cases is that I award 57-105 fees, because again, this is not complicated. They're entitled to take the deposition. This is a early 2020 case. Should be done by now. So, all right. So I'm gonna need an order from you, Mr. Perkins, after you circulated it, forward it to my office email address in Word format, please.
Will do.
All right. Thank you.
Thank you.
Thank you.
Mm-hmm. All right. Next case is, you're going to excuse me, everybody, because I've had an operation in my eyes. It makes it difficult to see. So I'm moving a little slowly. I believe it's 20 CA 2616, Watkins versus Edison Insurance Company. Who's here for the plaintiff? Anybody? Okay.
Yes, Your Honor, Ashley Cooper on behalf of plaintiffs, attorneys Jamie Watkins and attorney Matthew Watkins.
Okay. And who's here for defendant?
Good morning, Your Honor. This is G. William Hunt here for Edison Insurance Company, the defendant.
Okay. Well, I reviewed this motion, and I guess my thought is that Mr. Watkins is entitled to represent himself. So, but the question is does he have, should he be representing Ms. Watkins? I don't know the answer to that question. Anybody want to make some argument?
Yes, Your Honor, if I may. I'm actually co-counsel with attorney Watkins. Your Honor raises a correct point that the rules do not contemplate when the attorney is also the client. And regarding his wife, attorney Jamie Watkins, we would also note that there has been no prejudice or any issues here whatsoever. The test contemplated in Florida is whether or not there are one of 4 things at play. One being the testimony relates to an uncontested issue. 2, testimony will relate solely to a matter of formality, and there is no reason to believe that substantial evidence will be offered in opposition to the testimony. 3, the testimony relates to the nature and value of legal services rendered in the case, which isn't the case here. 4, disqualification of the lawyer would work substantial hardship on the client. Again, here, the client is the attorney, and or the client is the attorney's spouse. But again, we are co-counsel. So the spirit of this rule is that a jury not be confused during a trial when an attorney is testifying and then acting as lead trial attorney. In the motion, it says nothing about prejudice at trial. I believe very specifically, the only issue is a concern regarding discovery and needing testimony. Indeed, both insureds, both attorneys, Watkins, responded to the request for discovery, the request for production, the interrogatories, and I don't think there was a request for admissions. Earlier this year in January, both attorneys, Watkins, Jamie, and Matthew, signed the verified interrogatories. So there has been no inability to get discovery. Moreover, both insureds are presently set for deposition. Now, one of the other issues that arises in these types of disqualifications is whether you have the right to depose opposing counsel. Here, we're not even making that an issue. Attorney Matthew Watkins is ready, willing, able, and already noticed to sit for deposition. So I'm a bit perplexed as to why we're here as well.
Okay, so
Neither
let's
myself
find out.
nor
Mr.
Attorney
Hunt,
Watkins were
what's going on
contacted.
here? This seems to be much ado about nothing.
Your Honor, our main issue just is that at trial, we believe that this could be confusing for the trier of fact or any jury, just because the opposing counsel will be testifying and also they will be making arguments, outside of just their testimony. And we think that it could be confusing for a jury to listen to the.
This is not even set for trial until January of 2022.
Yes, Your Honor. But as stated in the motion, we still believe that he will be a material witness. He possesses information. He was the one who handled the claim pre-suit, and now he's still handling the claim. And he is an insured under the policy. He's an owner of the home. He will be of necessity be called as a material witness in the matter.
Right.
Go ahead. Sorry.
The motion to disqualify is denied at this time, but without prejudice. You can re-raise it in other grounds if you have them closer to trial, given that there is a co-counsel on this case. The only thing that I could think of that might cause you a problem and might be some concern is if we waited until right before trial and say, oops, no, we need to have another attorney involved, which would delay the case, 4 to 6 months. But that's not going to happen here as long as there remains co-counsel on the case. And then we can deal with whether or not the jury is going to be confused by this. Hopefully this doesn't even get to a jury trial. I have to say though, you guys win the prize. I have 500 of these Hurricane Irma cases, and this is the first of these motions that I've ever seen. So congratulations. I'll need an order from you, sir, with regard to this order after you circulated it to opposing counsel. Please forward it to my office email address in Word format.
Thank you, Your Honor.
If I may, could the order specifically state what you just stated, that it would not be an issue at trial if we appear as co-counsel?
No, that's not what I said. What I said was it won't be an issue for me to, for example, not address this now, which is essentially what I'm doing, and waiting to closer to trial, because it's not going to delay the trial because you guys are co-counsel. That's what I said.
Thank you. I appreciate it.
With regard to anything else, I'm basically punting it to see where we are when we get closer to trial. I don't know whether this would be handled on another motion to disqualify or a motion in limine or a motion, a pre-trial motion about court conduct of some sort, which I suspect would be a way that I could handle it. Just like I do with when I have, a lot of parties and a lot of attorneys, who's coming up to the bench when we have an objection that the court has to hear some argument about. So those are not very complicated. My only concern for Mr. Hunt's client would be if I waited and then you guys withdrew, then we might have a problem. But as long as you're co-counsel, I don't have a problem at this time. All right?
Yes, ma'am.
All right, thank you.
Thank you.
Have a great Thursday.
You too. Madam Clerk, I forgot to check in with you. You okay? You want to just wave if you were okay? Any
I'm
questions?
good.
You're
I'm good,
Okay.
Your Honor.
All right, thank you. All right, next case is Juan Santiago versus United Property, 20 CA 2982. Who's here for the plaintiff? Anybody? Nope. How about defendant? Doesn't look like it. Huh, that was defendant's motion to strike plaintiff's first amended complaint. That's how it's titled. It wasn't actually that. That's not exactly the substance of it, but okay. So Madam Clerk, just put that down as a no-show because I don't see that. Oh, wait a minute. It has fallen off my docket, which means there might have been a last minute cancellation. Hold on. Yeah, it looks like it was canceled. All right, so just put it down as a cancellation. All right, excuse me. Next case is Able versus Tower Hill, 20 CA 3442. Who's here for the plaintiff?
Good morning, Your Honor. This is Elise Malouf for the defendant. There's no counsel for plaintiff here for the matter because we filed a notice of cancellation.
Okay.
Probably just a few minutes ago.
Okay.
Okay.
Well, I appreciate you letting me know though, because we just sit here wondering what's going on.
That's what I figured. It was agreed to, so we're going to be submitting an agreed order, hopefully today or tomorrow.
All right, just to be forewarned, you guys were here on your motion to abate. I am going to need to have some sort of deadline, so I'm not just going to abate it like on into the future whenever you guys decide to ask for me to reinstate it. You understand?
Yeah, we'll put. I'll talk to counsel for plaintiff, and we'll put a date, 30 day, 45 days, whatever.
Yeah, whatever. I mean, if you got too long, like you got 180 days or.
I don't anticipate that. I don't want to speak without her here.
Yeah.
We'll
Okay.
We'll talk about that and submit an agreed order with a time period in the order.
All right, and please submit it to my office email address and work format.
Is that to the?
Madam Clerk.
Sorry.
I'm sorry, Madam Clerk. I'm here for this hearing as well. I don't know if you need my information. Do you have all that? I'm with U.S. Legal Support.
Oh, I called U.S. Legal this morning, so I know it was a last minute cancellation. So you're free to go. Thank you.
It's the office email address. I think it's Tammy Alexander at ca.cjis as in Sam20.org.
Okay, yeah, I see that on your website.
Yep.
Okay, I thank you.
Thank you.
Nice day.
Thank you. You too.
Bye.
All right, Madam Clerk. So that's it for the 8:30 docket. We have an 11 o'clock, which is Viverka versus Edison Insurance, still on the docket. So I will get back on at 11 o'clock, and then we have 1:30s also.
Yes.